The Nebraska Supreme Court hearing arguments today on some petition signatures for two medical marijuana ballot measures that passed last year.
The case moved to the High Court after a district judge dismissed the lawsuit, citing notary malfeasance. Details in our top story tonight at 6. The state's highest court today hearing arguments from all three sides in that case. Back in June, a district court judge ruled to dismiss former state Senator John Kuhn's lawsuit seeking to avoid Nebraska's medical marijuana ballot measures. Now, the judge found there were enough legally sufficient signatures. Secretary of State Bob Evnen filed then a cross-claim in Kuhn's suit, trying to remove the petitions after he certified them back in September of last year.
Yeah, voters in November last year approved both measures to legalize medical marijuana and establish an oversight commission. The attorney representing Nebraskans for medical marijuana says there's no evidence or allegations that the verified signatures were, quote, procured by confusion, fraud, or duress. Attorneys representing the state want the case to be remanded back to the lower court for phase 2 of trial.
Allowing the district court's opinion to stand would allow merely two bad actors to fraudulently place any measure on the ballot, so long as they both invoke the Fifth Amendment.
To be clear, the relief we're seeking is modest. We are not asking this court to toss the petitions in their entirety. All we're asking is that this court reverse and remand for a second phase of trial where the sponsors will have a chance to prove that they gathered enough valid signatures.
We ask as a practical matter for the benefit of the parties, for the benefit of the lawyers, and most importantly for the benefit of the public, can Secretary Evnen certify an initiative, pull the plug at the last minute, admit he has no standing under the exclusive statutory provision, and then circumvent that through the Declaratory Judgment Act.
Now, the attorneys for that ballot sponsor also are arguing that the secretary does not have standing in that case, citing the state duty to certify legally sufficient ballot initiatives. So far, there is no timeline for a decision from the justices in that case.